Good day, everyone. I am Dr. Parinita Goswami, Assistant Professor of Law at Manipal University, Jaipur. Let's start with the introduction of the topic. Today, we will thoroughly explore the intricate and delicate subject of interparental child removal and the numerous difficulties it entails. Professionals, communities, and individuals must comprehend these problems and their tangible effects on families. Let's start with the overview. Interparental child removal refers to the intricate and delicate matter of children being separated from one or both parents because of different family situations such as divorce, custody battles, or domestic violence. The topic at hand presents a variety of complex challenges that have a significant and far-reaching effect on the overall welfare of the children affected. Kid abduction, which refers to the unlawful act of removing a kid from their habitual residence without sufficient authorization or agreement, is a substantial worry in such circumstances. To resolve such issues, it is necessary to consider variables such as judicial jurisdiction, relevant legislation, and international treaties. Establishing judicial jurisdiction is of utmost importance, requiring careful consideration of concepts such as lex cause, lex fori, and lex domicili as outlined in private international law. The psychological impact on children who experience parental separation is significant, influencing their cognitive and emotional growth. Primary obstacles: legal complexity. Managing the intricate legal framework of child custody and relocation across many jurisdictions while considering the kid's best interests and parental rights. Emotional impact on children. Children may undergo psychological distress and anxiety because of sudden alterations in their living conditions and strained parental ties. Parental conflict. Elevated levels of discord between parents might impede efficient communication and collaboration, resulting in adverse effects on the child's adaptation. Psychological burden on parents. Both parents with custody and parents without custody may undergo considerable psychological strain, which might manifest as emotions such as sorrow, mourning, rage, and bitterness. Effect on parental rights. Striking a balance between parental rights and the child's well-being presents difficulty in reaching equitable solutions. Interdisciplinary collaboration. To effectively resolve issues, it is often necessary for specialists in the fields of law, mental health, and social work to work together and holistically meet the child's needs. To comprehend and tackle these issues, it is necessary to do a thorough analysis of the legal, emotional, and social and ethical aspects associated with cases of interparental child removal. Let us discuss some examples. Although I cannot share real-time or specific ongoing instances owing to the privacy and ethical concerns, I may present hypothetical scenarios that demonstrate the difficulties involved in interparental child removal. International custody dispute. Situation: Sarah and James, a married couple, move to different countries in pursuit of employment prospects. Their marital relationship declines, resulting in divorce. The couple has a daughter named Emma. Sarah elects to return to her place of origin with Emma, while James objects, sparking an international custody conflict. Dealing with rules that apply across many countries and deciding where the child usually lives are intricate legal factors to consider. Intimate partner violence and legal dispute over child custody. Situation: Lisa and Mark, a couple with a documented record of domestic violence, decide to end their relationship. Lisa, the aggrieved party, is pursuing exclusive custody of their two children, citing apprehensions regarding their safety. Mark, refuting the accusations, is seeking shared custody. The court must weigh the children's protection against Mark's parental rights, considering the facts and the possibility of psychological stress. Opportunities for relocation and advancement in one's career. Now let us understand this with some situation. David and Rachel mutually decide to end their marriage in a friendly manner, reaching an agreement to share the responsibility of raising their child, Alex. Rachel is offered a position in a different city, but David is against moving since he is concerned that it will disrupt Alex's stable surroundings. The court must prioritize the assessment of the potential influence on the child's welfare. Now we move to the parental alienation. Some situation we have. Michael and Laura have joint custody of their daughter, Emily. Laura, harboring resentment over the divorce, exhibits actions that isolate Emily from Michael. Emily exhibits hesitance in allocating time for her father. The court is confronted with the task of recognizing and resolving parental alienation to preserve Emily's relationship with both parents. Next is cultural and religious differences. Again we have some situation. Maria and Ahmed, who come from distinct cultural and religious backgrounds, go through a divorce. Malik is their offspring. Maria is pursuing exclusive custody since she is worried about Malik's exposure to Ahmed's cultural and religious customs. The court manages cultural conflicts while assuring Malik's exposure to the cultural backgrounds of his parents. These hypothetical situations illustrate the varied difficulties in cases where parents remove children from each other, emphasizing the necessity of a thorough and a personalized approach to tackle the distinct conditions of each family. Now, what will be the judicial approach? After resolving the first matter of jurisdiction, the court proceeds to deal with the implementation of orders from foreign courts, if necessary. Typically, the injured spouse seeks legal recourse in the courts of the nation where the child was wrongfully taken. In that jurisdiction, the court has the authority to issue orders for the repatriation of the relocated kid to their nation of habitual residence or compel the other parent who relocated the child to attend the upcoming court session. Consequently, following these instructions, the distressed father seeks legal intervention in India. and asks the Indian courts to implement these instructions. To secure legal action, the injured party depends on the two crucial principles: the principle of committee of courts and the principle of first strike. These principles acknowledge the presence of an international society that necessitates mutual respect in legal systems. The principle of committee of courts pertains to the observance of goodwill behaviors, deeds, and regulations by nations in their interactions with one another. Although the court's main responsibility is to enforce its laws, it is possible to show deference to the laws of other countries. While Section 13 of the Code of Civil Procedure acknowledges the principle regarding judgments made by foreign courts, it does not explicitly cover foreign orders. Nevertheless, the court has repeatedly maintained that the concept of committee must be upheld, particularly when it comes to interim orders issued by foreign courts. Enforcement can only be refused in exceptional or compelling situations. The concept of the first strike is grounded in a comparable rationale. According to the statement, if there is no uncertainty about the authority of a foreign court, the court that made the initial order can be given appropriate consideration. Therefore, precedence is granted to the ruling of the court that issued the initial decision. While the courts endeavor to uphold orders issued by foreign courts, they consider various additional criteria. In a series of rulings, the Supreme Court has established that these principles are not without exception and must be weighed against the child's best interest. The implementation of the principle of committee may be disallowed if it conflicts with the child's welfare. Since courts have recognized that while the principle of committee is important, it should not be prioritized over the child's well-being. Welfare pertains to a setting that promotes the ideal advancement and maturation of a child's personality. Moreover, the notion of committee requires not the imposition of its rules, but thoughtful deliberation. Likewise, the courts have determined that the first strike concept can only be applied at the court's discretion and should not be used if it goes against the child's best interests. Furthermore, the court judiciously considers its parent parte jurisdiction in addition to the well-being of the child. When a court reviews issues concerning the guardianship of a minor, it does so because of its jurisdiction. In the case of Dr. V. Ravi Chandran versus Union of India, the Supreme Court endorsed the parent parte principle, emphasizing that it should be used with due regard to the well-being of the child. In the case of Nitya Anand Raghavan, it was also determined that the court, when exercising its parent parte jurisdiction, must consider several considerations, including the child's growth and the minor's desire to live in a specific location. Given these factors, the court consistently employs the rules of committee and first strike wherever feasible. However, this is contingent upon the well-being of the child and the court's exercise of its parent parte jurisdiction. If the court decides not to utilize these principles and instead prefers to evaluate the case based on its substance, it would be directed by different provisions of the Hindu Minority and Guardianship Act 1956 and the Guardianship and Wards Act 1890, which are the primary legislations that govern custody law in India. However, the final determination is also contingent upon the well-being of the child. The stipulations outlined in Section 7, 9, 12, 13, 17 and 25 of the Guardianship and Wards Act 1890, as well as the Section 6 of the Hindu Minority and Guardianship Act 1956, unambiguously establish that the well-being of the child takes precedence over the legal rights of the parents. What is the importance of the international conventions? Two prominent international conventions are highly significant in situations involving child abduction. The United Nations Convention on the Rights of the Child and the Hague Convention on the Civil Aspects of International Child Abduction. The UNCRC places utmost importance on safeguarding the welfare of the child, making sure that their voices are considered in decision-making process that affect them. As per this convention, it is the responsibility of the state to uphold a child's entitlement to preserve their identity without any illegal intervention and to have consistent communication and personal connections with their parents. Nevertheless, every action must prioritize the child's welfare. States are also required to actively address and prevent illicit transfers. Following the ratification of the convention in 1992, the Indian government implemented the National Charter for Children 2003, which prioritized working in the child's best interests. In 2015, the Juvenile Justice Act underwent amendments that prioritized the restoration of the child's previous economic situation and reunification with their family. These laws are frequently used by the litigants to request the return of a child to their home country. Nevertheless, examination of several legal precedents suggests that the judgments are rendered with consideration for the well-being of the child. And while the convention has been officially approved, it does not offer substantial support to those wanting to return to their home country. The Hague Convention on Child Abduction addresses instances of cross-border parental child abduction. The purpose is to restore the child to the original circumstances before the occurrence of the abduction. The convention pertains to instances where a child under the age of 16 is unlawfully taken or kept in a country that has agreed to the convention. The authorities in that country are required to release the child if they determine that the child has been wrongly kept or abducted. The agreement offers only a few justifiable reasons for the country of asylum to reject the repatriation of the child. The authorities of the child's usual place of residence maintain jurisdiction over such affairs. India is not a signatory to this agreement. Hence, it is not legally required to return a child under the provisions of this convention. The Dhanvanti Joshi decision established that the non-signatory countries should evaluate such matters based on their merits, as determined by the Supreme Court. The Nithya Raghavan case upheld the idea that non-signatory countries have the authority to carry out comprehensive proceedings in similar circumstances. In child abduction cases, the Indian judiciary gives primary importance to the welfare and well-being of the child. Now, what are the legal challenges? Dispute over custody and the legal framework surrounding them. Imagine a situation in which conflicting parental rights spark a protracted custody dispute. The child's fate is determined within the legal framework and custody rules. Court rigorously assess variables such as the child's attachment to each parent, their physical and mental well-being, and the ability of each parent to provide a stable upbringing. Parental rights and obligation. Understanding the complex system of parental rights and responsibilities is essential in a situation of post-divorce issues. Precise legal instructions are crucial in protecting the well-being of the child and preventing any potential harm that may result from ambiguous or disputed arrangements. For example, a custody agreement can clearly outline visitation schedules, financial obligations, and decision-making powers. Next is transitional custody challenges. Imagine a situation when a child becomes involved in a custody issue that spans across different countries. The intricacies of custody difficulties that occur across national borders go beyond legal limits. The Hague Convention serves as a prominent source of guidance, providing a legal structure for settling conflicts and guaranteeing the prompt return of the child to their usual place of residence. Concrete examples in the real world, including situations when parents come from different countries, highlight the worldwide consequences of these legal dilemmas. Now, there are some emotional challenges. Effects on children. Consider a youngster experiencing mental distress during parental separation. The psychological consequences are significant, possibly resulting in enduring impacts on their mental and emotional welfare. Studies suggest that children who experience divorces characterized by intense conflict may exhibit signs of anxiety, depression, and challenges in establishing trusting connections. Parental emotional strain. During a divorce, both parents experience intense emotional distress and feelings of remorse, which can hinder their capacity to effectively collaborate in parenting their children. It is crucial to acknowledge and deal with these emotional difficulties to establish a positive and balanced atmosphere after a divorce. One can investigate concrete instances of counseling and support groups designed to assist parents in managing emotional discomfort. Now, communication breakdown. Consider a scenario in which failures in communication between parents intensify tensions. It is crucial to prioritize effective communication techniques, Mediation and counseling treatments are crucial in reducing disagreements and fostering a positive co-parenting dynamic. Role-playing scenarios can be utilized in training courses to provide teachers with practical communication tools. Now, there are some social challenges. Stigma and social perception. Examine the cultural stigmas that divorced or separated parents may face. Adverse impressions can infiltrate the child's social connections and impede parents' capacity to reconstruct their lives. It is imperative to confront these stigmas to ensure the overall welfare of the entire family. Examining case studies that demonstrate effective community projects that challenge stereotypes might motivate educators to establish inclusive environments. There are some support systems. Within a supportive community, friends and family serves as a safeguards for families undergoing interparental child removal. An essential component is a resilient support system, providing both emotional and practical aid. Cultural consideration. Comprehending and valuing cultural subtleties becomes of utmost importance in delivering efficient legal and social solutions customized for varied groups. One can analyze instances of counseling services and legal support that are culturally sensitive to emphasize the significance of inclusivity. So, what are the strategies for dealing with challenges and resolutions? Mediation and alternative issue resolution. The advantages of alternate dispute resolution strategies become apparent, promoting a more harmonious and focused resolution that prioritize the well-being of the child. Concrete instances of families reaching mutual agreement through mediation can serve as the compelling demonstrations of effective methods for dealing with conflicts. Child custody arrangements and collaborative parenting. Case studies can demonstrate the need for explicit instructions to minimize the conflicts and foster stability for the child. Examining parenting plans that prioritize the child's welfare, providing a clear framework for making decisions and distributing duties, might yield significant observations. Child-centered approaches. Empirical evidence illustrates how child-centered methods result in fairer custody agreements. An analysis of instances where the court actively solicits the child's perspective, ensuring that their opinion is considered in custody determinations, can emphasize the significance of a child-focused approach. Let's conclude this topic. The topic of interparental child removal is a worldwide concern, particularly addressed by the Indian judiciary, which deals with intricate legal matters while giving priority to the welfare of the child. Indian courts prioritize the well-being of the child over parental rights while also acknowledging international conventions such as UNCRC and the Hague Convention. Indian courts rigorously examine abduction cases, prioritizing the child's well-being and their right to contact, even though India is not a member of Hague Convention. The court's approach exhibits a harmonious equilibrium between global standards and the welfare of the child. Indian courts must provide effective remedies to protect the right of children in response to global changes. Empathy, communication, and prioritizing child welfare are essential for tackling these problems and promoting resilient family situation in the face of complex circumstances. With this, we come to the end of today's lecture. Thank you very much.